Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. As you all are, I'm sure, well aware. So, hi. How are you? I apologize for being late. I will tell you the tale if you'll sit with me for just a moment. It's not a long story. Lady Rackets and I finished watching an episode of Game of Thrones about 30 minutes ago. Something like that. I took care of a couple things around the house, and on the way downstairs to the vault, I noticed something out of the corner of my eye. Now, going back a little bit, I have moved over a year ago from my old house into my new house. I still have the old house. I don't want it. I don't want to have it, but I do. There's not much I can do about it until some things have to happen for that bad boy to get sold. But that being said, I went and I picked up some stuff from the other house. A couple things today, including a fully functional Nintendo Entertainment System power pad and light gun. You know, the deluxe pack with the game cartridge with Duck Hunt, Super Mario, and the racing game, or the track and field. I have all of that. So anyway, along with that, I picked up something Lady Racket spotted. It was a red cassette tape. And it's like old Sunday school songs, right? From when she was a kid. And so we brought it home. Despite not having a tape player, I don't know. I figure I could find one somewhere. But we brought it over to the new place. And on the way downstairs to the vault, I look and I see the little red cassette and like 18 miles of magnetic tape pulled out of it. So I don't know if the baby found it or if a cat got it, but it was all for naught because it is absolutely trashed. Oh, God. So anyway, sad day. So thank you guys for joining me on a Saturday. A Saturday in which, I normally don't, I try not to stream on Saturdays and Sundays unless something happens during the week. And as I announced yesterday, I was very, very taken by the Wu flu or whatever it was. It was unpleasant, we'll just say. I just laid in bed for like 16 straight hours shivering. So that was fun. What is this my thing? This is my. So, I just laid there in sadness. It was great. I really liked it. But I wasn't able to do a show, and for that I am deeply and truly sorry. I don't like canceling shows. I really don't. Yeah, that's another interesting thing. I don't know if you guys care, but I'm going to talk about it anyway because it's the beginning of the show. The beginning of the show is a great place to kind of fill out some backstory and less important things, before the main show starts as people filter in, because you all expect me at this point to be late and gay. So when I am, I still have to provide time for those who may have been caught, thinking I would be later and gayer. Anyway, so Lady Rackets and I are doing a marriage Bible study together. And this is not the story I'm telling. Different story. Hold up. I was at a men's conference the other day, and one of the sessions was on managing time, right? It's all about managing time. And this wasn't in the context of like setting up an Excel spreadsheet and a calendar and all of that stuff. This is about managing time between work-life balance, stuff like that, in the context of being a dad. Okay. And one of the things it was saying was, some people can get addicted to doing work and stuff like that, and they can make their job their escape from their family, which I think a lot of guys do. And I don't know that that's necessarily a bad thing, because if your work is part of your escape, that's good. That's good, I think, because you should want to work in some way or another, some capacity. But part of it was this idea that if you feel bad taking a day off, like you might have skewed priorities or something like that. So long story short, and there's no profound point here. Long story short, I think I have skewed priorities. I hate taking days off. I really do. So all of that to say that was it. There you go. Anyway, so today, this is an off the cuff sort of show. We're gonna go through this Kesha, Lucas Z. Gottwald, Kaz Money Inc., Prescription Songs LLC versus Kesha Sebert. I'm pretty sure Kesha was just ordered to pay a whole bunch of money, and we're gonna read about it. We'll read about it and see what it says. I know a bunch of people want me to show this to Ty or whatever, and I'll send it, of course, over to their team, and they will do with it what they want. There's some big differences here between this case and Vic's case, of course. We do have defamation, and I think a lot of people are focusing in on the public figure argument, and that's an interesting one, especially because the public figure argument is largely controlled by federal case law. And so while this takes place in New York, therefore it is inherently different from Texas, there are some interesting things about it. And of course, I mean, I'm not going to harp on this too much, but if you read this case and how they determine public figure status, it's much akin to what I and other people were saying as we looked at whether or not Vic is a public figure. That Vic doesn't seem to fall into the public figure status. Sure, he might be a big name in anime, but he's not a household name. For general purpose public figure, he's not. He's just not that popular in any sort of sense, right? I mean, he's got 112,000 or 122,000 Twitter followers, for example, which sounds like a lot until you realize, Mundane Matt has more than that in YouTube subscribers. I think maybe he fell below that, but at one point at least, Mundane Matt had over 130,000 YouTube subscribers. A jackass like me has almost 78,000 YouTube subscribers. So that number means less and less. On the average day. I'm by no means a household name. In fact, I can go around the cities that I live in, and unless you know me already, they have no idea that I'm on this show, that I do this show. It's just not, it's the 100,000 people in the context of the earth, even if it's primarily concentrated in the US, is an abysmally small number. So when we're talking about this public figure status and what makes a general purpose public figure, we argued from the start, we being me and most of you guys, that Vic is probably not a general purpose public figure. So we're going to take a look at how this court interpreted it. Now, I want to point out that there is a fatso on Twitter, what's his name? A Park, who's arguing Gertz versus Welsh, which is one of the cases they applied. And I, if I remember correctly, suggested that Vic was a general purpose public figure under Gertz, and would also be a public figure, a limited purpose public figure. But I don't remember that specifically, so I don't know. I haven't seen much from that guy in a while, but he might have blocked me. Oh, speaking of Twitter, you may notice that I am not, or I didn't post this on Twitter, and that is because I am on a temporary suspension, 12 hours from Twitter. And guys, I'm going to show you why. I'm going to show you the exact thing that caused it. As soon as I find it here. Thought I would have it here, but apparently I don't, but I do have it. Oh, come. Or I can get it to me. It is from John Michael Kelly, who may or may not be a pedophile. I don't know. I've heard that he is. He says he isn't. So I don't know what to tell you about that one. So far, I mean, we've got conflicting accounts on whether or not he's a pedophile, and God, the jury's out on it for now. I don't know if John Michael Kelly ever diddled his sister. He seems to think that I said that he did, which I didn't, by the way. I didn't say that at all. He also says, because the man doesn't know how to read, doesn't know how to read, or is stupid, or both. I'm going to go with both. But or listen, apparently. Hold on, I'm getting these pulled up right now. He didn't pay attention very well when I was doing a live stream from a different location, and I said that there was a video out there that tried to put these things together, and people needed to go check it out and make up their own mind if they cared, right? That apparently, according to may or may not have diddled his sister, John Michael Kelly, and again, I don't know, but he's really, really fighting hard against this accusation. So what does that mean to you? I don't know what it means to you. He thinks that I endorsed the video or promoted the video. I said, you can make up your own mind. I don't know anything about it. I've never even watched the video. I think it was taken down. I think the video was taken down by the owner, but I've never seen it. Didn't claim to have seen it. Couldn't validate anything of it. I said all of that. But may or may not be a pedo, John Michael Kelly seems to think that I said he was a pedo. I don't know, John, if you're a pedo or not. I don't know who you even are. I don't know why you bother me. I don't care about your life. I don't want to know if you're a pedophile. I don't want you to be a pedophile. I don't want to know that you did pedophile someone. Stop being a pedophile if you are. Get help or whatever. I don't care. If you died in a tragic accident tomorrow, I wouldn't even know about it. That's how insignificant you are to me. Leave me alone. But anyway, let's see. So let's take a look at these. This is targeted harassment according to Twitter. So this little vagina, John Kelly. I shouldn't call him a vagina. Vaginas are great. This little cunt, John Kelly, said that this was targeted harassment. He went crying to the Twitter police for these very, very offensive tweets. I mean, guys, I know I need to calm down my language on Twitter. I'm told all the time by very concerned citizens that my language on Twitter needs to calm down. Okay? And I agree. I was way too harsh to John Michael Kelly on Twitter on this occasion. And I want to own up to what I did. So I'm going to show you guys what it was. Because, you know, it was brutal. Very, very bad. All right. Here's a look. Okay. Here is. Ha! All right. We've temporarily limited some of your account features. Okay? Violation of the Twitter rules, abuse and harassment. You may not engage in the targeted harassment of someone or incite other people to do so. This includes wishing or hoping that someone experiences physical harm. All right, you guys tell me. Like I said, can't read or stupid, going with both. Brutal. Look at that. Look at all the harm that was wished. Clearly targeted harassment. Targeted. Right there. Next one. Here you go. I'm not sure which is worse, his stupidity or his pathetic nature. Oh man. I'm so sorry for abusing someone. I understand now what I did wrong. Let's read. There's one more tweet. Of course I'm hiding the ball, right? This is how you teach a class or whatever, is you hide the ball and make the class like, aha, there's the mystery. Here's the hidden ball. The third tweet. Apparently you don't know how to read or are stupid or both. Going with both. There it was. That's it. That is abuse and harassment under Twitter's rules. Now, mind you, this piece of shit has spent the entire day talking about me on a thread in which I am tagged by him all day. Tweet. I didn't even respond to his tweets. I think in one of them I did. The others were to the person he was responding to. So that's it. There it is. Apparently you can't say a fucking word on Twitter. Not a word. Because you'll get banned for harassment for saying that someone is stupid. I mean, I didn't call him a pedo. Oh, it's not. I mean, you say it's just sock accounts mass reporting me. This is John Michael Kelly specifically reporting me. John Michael Kelly is a complete bitch. So, and he knows it. But now he'll know. He'll know it. So again, I don't know if he's a pedophile. I don't know if he's a kid diddler. Someone said he was. You guys can make up your own mind. But there you go. There you go. Just 12 hours, though. I think I'm down to like 6 hours left. So by the time the Twitch stream is over tonight, we'll be back. We'll be back in full swing. I need more mods. Why do I need more mods? Oh, because we've got the sex bots in here? Sex bots are great. I don't know why you guys are complaining about the sex bots. Anyway, so that's the Twitter story. I didn't want to, dwell too long. Oh my goodness, too long on it, but that's what it is. As for my personal woo flu, let me clarify some things. I believe it was a result of I ate some homemade salsa that was in a jar in my fridge. If you watched the cooking stream, you saw me eat it. Not the first jar that I finished. It was the second jar of Reaper salsa that I added in because I didn't have enough salsa from the first jar. That Reaper salsa was old. I didn't think it was that old, but apparently it was too old. It's the only thing I can figure out because all of my family ate everything else that I ate. It was just the salsa. So either that or else I got whatever horrific virus that they had. But it seriously, it was like 16, 20 hours of suffering. And then it was over. I woke up relatively okay today, but, yeah, you would not have wanted me on last night. It was like, I was sitting just shivering in bed. All right. So here is the case. Here's the case. We've got, Lucas Z. Gottwald, Kaz Money Inc., Prescription Songs LLC versus Kesha Sebert. I said Katy Perry. She's I should probably change it to Kesha, but Katy Perry is she's not implicated in. I got my parties backwards when I was thinking of this. Kesha says that this other guy raped Katy Perry. That's what happened. Which apparently is untrue. And so now Kesha's got less dollar signs in her name. Also, Katy Perry's better looking than Kesha. I'm just gonna. That's not really relevant. I just wanted to point that out. Okay. What else do we have? Let's hit these super chats and then we'll hit the ground running. And it is. I am wearing the wrong shirt. I might have to take a break in just a minute and go change shirts because I'm in a shirt that is too warm. Too warm. Okay. No. Gimme Skittles Now says, tonight's stream brought to you by Raid Shadow Legends. If Raid Shadow Legends wants to advertise on this show, they should reach out and talk to me. I will take their money. Jack, I don't know if I would or not. Jack Riley says, post hoc ergo propter hoc for your Coomer brain in the last conversation. Fun to say, but second to Ve Victus. I still say sic semper tyrannis. But thank you for clarifying that. And by the way, we will continue conversations, but not tonight. Not tonight. Since this is an off night show, and I was unable to announce it, I didn't want to do the conversations. I want to spread the love of the conversations. Mopsync says, after your recommendation of the O-Band 14, I've now moved towards the realm of bourbon. Some favorites I found are Elijah Craig, Larceny, and Angel's Envy. All fantastic, by the way. I would recommend any of those three for next month's whiskey review. Aside from having had all three of them already, I may do that, but I always kind of keep my eye out looking for something I haven't had. But this month, I'm not sure what to do yet. I took a peek at the liquor store today. Haven't been there in a little while. So I was looking around. There is this really expensive Irish whiskey there. Well, I say really expensive. It was like $200, which is pretty expensive, but not crazy expensive. And I was surprised because this is a small town liquor store. I wasn't even at the big one. But yeah. So we'll see. I'm not sure what to try yet this month. Oh. Hold on. Hold on, this is important. Sometimes just a second, sorry. Anyway, that's a sad story. Maybe I'll tell it at some point. But if you're watching and you just got that email, peace be with you, my friend. Godspeed. Okay, sorry. Timothy Reaper says, I say we punish Nick for his tardiness and homosexuality by making him read dad jokes. I'll start. What do you call a cow with no legs? Ground beef. What do you call a cow with 2 legs? Lean beef. Oh, okay. Oh my goodness. Cody M says, hey Nick, first super chat. Hey, thanks buddy. Welcome. Saw a previous live stream where you said you have urticaria from heat. Wild because my wife has been diagnosed with cold urticaria. No one ever believes her. Thanks for all the entertainment you provide, man. You know what? I believe you and her because a buddy of mine on the Facebook, he developed cold urticaria actually not too long after I developed the heat one. And it was crazy. Like he has to wear gloves to like drink a cold beer or whatever. It was nuts. But yeah, I believe you 100%. It sucks. Dorby says, sci-fi promised me sex bots. It's 2020 and the so-called sex bots are texting dodgy links to chat rooms. Trust nerds to have no idea what real sex is and get it all wrong. Yes, Yes. Suppa Sandwich says, finally picked up a bottle of Nadura after trying the Glenlivet 12 per your recommendation a few months ago. My God, Nick, the Nadura is out of this world and worth every penny for the flavor. Would you take a drink with me? I will. I have to get out of this shirt. I'm going to die. I'm going to die. I'll be right back. Chair Coon will keep you entertained for just a moment. Here, I'll give you a bigger Chair Coon screen. I'll be right back. And then, yes, I'll take a drink with you. Oh boy. Sorry. Usually what I do is I leave my computer off in the vault before the show so that it's not hot. My son was in here playing Minecraft. Oh, I forgot to actually, I was supposed to transition this over to the full Chair Coon, but I forgot. Stupid thing. Oh. Vine the cold one. Hey man, thanks. Okay, next. Drink. All right, I don't have a Nadura supper sandwich, but I do have this. This is the Iliac. Got about a drink left, so I will share it with you. This bottle came from Scotland. I think I can order it in the US, but I've never seen it for sale on any shelves locally. So anyway, this is to you, buddy. Sup a sandwich. Oh, it's good. Iliac. Not the Iliac Guardiola or whatever, who may or may not be a pedo as well. Just kidding. I guess he's not because he married her. That made it okay. For Monica, anyway. Minecraft yourself stream when? I don't know, man. Great. I'm sitting here just scratching. Like, you see my shoulders moving? I'm just scratching all of the various itchings that are going on. All right. And there's one more chat here. Little Nikki says, Nick, have you tried the Balvine Doublewood 12-year. It's pretty good. I have. It's a good whiskey. You're right. It's great. I don't order it often. I've never bought a bottle, but I've had it at a couple restaurants. Yeah. Hold on, I'm scratching. Oh. Really tired after all that scratching. Oh. Woo. Sorry, I was doing research for the show. Just kidding. Let's do it. Let's do this. I got junk in the way of my monitor here. Let's read this stupid lawsuit, shall we? Blah, 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 blah. Decision in order. In this defamation and breach of contract action, plaintiffs Lucas Gottwald, Kaz Money, and Prescription Songs move for partial summary judgment against defendant Kesha Rose Sebert. Kesha opposes and moves for partial summary judgment against plaintiffs, which they oppose. Plaintiff's motion is granted in part and defendant's motion is denied. So there we go. Gottwald, known professionally as Dr. Luke, is a songwriter and music producer. In 2005, he heard Kesha's demo tape and decided that he wanted to work with her. This is probably why. Did you see how stupidly he spelled all of his names? All of them. Even his own name, Lucas Z. Gottwald, professionally known as Dr. Luke Kazmoney. Like, this is an idiot. But we don't get to defame people just for being idiots. But this is probably why Kesha has a $sign in her stupid name. All right. That he wanted to work with her. After meeting, Gottwald and Kesha each retained independent entertainment counsel to negotiate an agreement for KMI, a corporation controlled by Gottwald, to record and produce Kesha's music. Kesha and KMI executed a written agreement dated September 26, 2005. The KMI agreement obligates Kesha to provide exclusive recording services to KMI for a specified term, which at KMI's election could be extended through the release of her 6th album, and to engage Gottwald as producer for at least 6 recordings on each album, for which he would receive royalties. Shortly after entering into the KMI agreement on October 5th, 2005, Gottwald and Kesha attended Nikki Hilton's birthday party at a Los Angeles nightclub. They both drank at the party. No kidding. On the way out of the club, Kesha alleges that Gottwald gave her a sober pill, which was really a roofie. No, don't. Ladies, come on now. If a man hands you a pill and says, "This be a sober pill," don't take the pill. Don't do that. Don't do that. All right. They proceeded to an after party at Paris Hilton's house. They went from Nikki to Paris's house, where Kesha had more to drink. Kesha became very ill, possibly because of food poisoning, alcohol, or a roofie. I mean, who can tell anymore? After vomiting in a closet, Kesha was kicked out of the party. This is the plot of last Friday night. Kesha only has a vague recollection of what happened next. It is undisputed that Gottwald took Kesha to his hotel. He says they walked. She thinks they took a car, and that she slept in the bed. Gottwald insists that he slept fully clothed on the couch and that there was no sexual contact whatsoever between them. The next morning, Gottwald got up before Kesha because he had to go to the recording studio. Before leaving, Gottwald told Kesha, who was feeling very sick, that she could stay at the hotel for the rest of the day. Though she has no memory of Gottwald assaulting her, Kesha maintains that he raped her during the night because she felt ripped and sore and experienced the after effects of a roofie. Footnote, many facts related to the events of October 5th and 6th, 2005 are disputed. The court does not know what transpired between the parties and is not tasked with fact-finding. That is solely the job of the jury. So there you go. There you go. On Gottwald's recommendation, Kesha subsequently hired David Sonnenberg of DOS Communications Limited as her manager. I mean, you know, why not if he just raped you or whatever? Sonnenberg immediately tried to renegotiate the KMI agreement because he secured a deal for Kesha with Warner Brothers. Gottwald objected to the Warner Brothers arrangement, asserting that it contravened the terms of the KMI contract. Kesha hired lawyers who challenged the validity of the KMI agreement and threatened Gottwald with bad publicity if he refused to give in to Kesha's demands. See docket 1764 at 3. Kesha has advised us that she has every intention of bringing all of your client's prior behavior to light in the event he continues to try and enforce what he believes incorrectly are his contractual rights. So that's a good threat. That's bordering on extortive. No big deal. KMI agreement, however, was not renegotiated. In 2008, Kesha changed representation and began working with Gottwald. Wait. Okay. She hired a new lawyer who helped her negotiate and execute amendments to the KMI agreement, including a letter agreement that capped KMI's ability to extend its exclusive arrangement with Kesha to the release of her 5th album instead of her 6th. Kesha also, she has 6 albums? Why? Kesha also later agreed to 2 additional contracts with plaintiffs, a co-publishing and executive administration agreement, dated November 26, 2008, governing the rights of Prescription, an LLC controlled by Gottwald, to publish her music, and an agreement dated January 27, 2009, between KMI and RCA, a Sony music label. In 2010, after releasing her first album, Animal, which included hit songs such as TikTok, Kesha achieved tremendous success. It is undisputed that Gottwald and Kesha worked together closely on the album. They were still, however, dealing with the fallout from disputes involving Sonnenberg, who had sued Gottwald. It was alleged that Kesha, through her mother, PB, told Sonnenberg on the night of October 5th, 2005, Gottwald drugged and raped her. So Kesha, through her mother, PB, names these people, told Sonnenberg that Gottwald drugged and raped her. Okay. On June 16th, 2011, at her deposition in that action, Kesha testified under oath that Gottwald never gave her a roofie. She did not remember telling PB that she woke up in Gottwald's bed without memory of what had occurred the night before, and she never had an intimate relationship with Gottwald. All right. She further testified that Gottwald never made sexual advances at her. PB testified at her deposition on October 18, 2011, that before meeting Sonnenberg, she was unaware of Kesha having had any kind of sexual relationship with Gottwald, or that Gottwald had given Kesha drugs of any kind, including a date rape drug. Oh, okay. At their depositions in this action, Kesha and PB explained their prior testimony. It is up to the jury to decide what testimony is true. All right. In late 2011 and early 2012, Kesha again sought to renegotiate her contracts with Gottwald. She hired counsel and did not show up for her recording sessions. Kesha's management team described their efforts as a jihad against Gottwald, who is no friend of an artist. Who'd she hire? We will jihad him. In an April 2nd, 2012 email, they wrote that they should battle Gottwald in the press and take down his business. In a May 25th, 2012 email, her management wrote that Kesha despised Gottwald and that after completion of the album that was underway, they wanted to ruin him. This is good business relations. In 2013, after Gottwald did not accede to Kesha's demands, she stopped working with him. She refused to deliver new compositions pursuant to the Prescription agreement and stopped paying royalties owed under the KMI agreement. Kesha hired 2 new lawyers, Mark Garagos and Kenneth Miselas. On October 30th, 2013, PB indicated that unless Gottwald released Kesha from all legal contracts and returned all of PB's publishing, she was going to tell the truth and make really public that Gottwald drugged and date raped Kesha. Again, this is extortion. Unless you can, I mean, on December 30th, 2013, PB emailed Gottwald's business partners that Dr. Luke abused Kesha both physically and mentally. See docket 1725. She then sent the email to Michael Eisel, the blogger who started the whole Free Kesha thing. Thereafter, PB and Eisel discussed edits to a message that he planned to send to Gottwald, RCA, and Sony on behalf of the Free Kesha movement, urging them to take the necessary action to end Kesha's horrendous contract that was signed by an 18-year-old girl who already suffered for her mistake. 18-year-old girl. I mean, legally competent adult who would, I mean, if you want to call Kesha legally competent, I don't know. But typically we presume an 18-year-old is able to enter into a contract. During the summer of 2014, Miselis met with Sony's general counsel and provided her with a draft complaint alleging that Gottwald had drugged and raped Kesha in 2005. Miselis informed Sony that the complaint would be filed if Sony did not let Kesha out of her contract. Kesha's team, including her lawyers and the PR firm SSKS LLC, so she's hired ISIS and the SS, prepared a press plan related to their impending litigation with Gottwald. The press plan stated, "Our goal is to help extricate client K from her current professional relationship with person L by inciting a deluge of negative media attention and public pressure on the basis of the horrific personal abuses present in the lawsuit." And yes, guys, I have seen the Johnny Depp lawsuit. I will cover it. I don't know how many times I have said I will cover it. I will cover it. Just chill. The press announcements were timed to achieve the maximum level of negative publicity. On October 14th, 2014, the parties sued each other in separate actions in separate states. Kesha sued Gottwald in California, alleging, among other things, sexual assault, sexual harassment, gender violence, and unfair competition in violation of California law. Gottwald commenced this case after the California judge determined that the governing contract's forum selection clauses mandated proceeding in New York. Kesha withdrew the California action. Plaintiffs filed their first amended complaint in December 2014, and in July 2015, Kesha filed counterclaims against plaintiffs and Sony, which plaintiffs and Sony moved to dismiss. September 2015, Kesha moved for a preliminary injunction seeking an order permitting her to make music without plaintiffs and releasing her from her agreements with them. About a month later, Kesha amended her counterclaims to include, among other causes of action, claims that she had previously brought in the California action, which plaintiffs and Sony then moved to dismiss. February 2016, after oral argument, the court denied Kesha's preliminary injunction motion and reserved on the dismissal motions. Guys, I think there's like 1,800 filings in this case. It's been going on a long time. By order dated April 6, 2016, the court dismissed all but one of Kesha's counterclaims and denied leave to amend because even if the sexual assault occurred, the counterclaims could not be maintained. Some claims were time-barred and there was no subject matter jurisdiction over others. Kesha appealed denial of the injunction and dismissal of her counterclaims, but later withdrew both appeals. Footnote: abandonment of her appeals is a fact that a jury could reasonably consider in assessing whether the California complaint was a sham or whether its contents are privileged. In January 2017, plaintiffs moved for leave to file a second amended complaint, and Kesha moved for leave to file amended counterclaims. The court granted plaintiffs' motion without opposition. By order dated March 20th, 2017, the court denied Kesha's motion, holding that her proposed amended counterclaims lacked merit. The court held that Kesha had failed to perform under the KMI agreement. It is not legally impossible for her to perform under the KMI and prescription agreements. The appellate division affirmed. She is getting blown out on these lawsuits. That's the long and short of this. All of Kesha's counterclaims have been dismissed, and the court found that she had failed to uphold her end of the contract. So the plaintiff is winning handily in this. By order dated August 31st, 2018. This is still the intro. This is still the facts and intro section here. Order dated August 31st, 2018. Court granted plaintiff's motion to file a third amended complaint, holding that a reasonable finder of fact could conclude that the California complaint was a sham maliciously filed solely to defame plaintiffs. Okay, so as we've talked about in other cases, or as I've talked about, your court filings are largely privileged, right? A court filing can't be defamatory on its face because if you're you're presumed to be bringing a lawsuit in good faith, and you have a right to bring that lawsuit even if your claims are incorrect or unable to be proven. Okay? If a jury or a fact finder could, oh my gosh, find that if they have some evidence to support the idea that the legal documents were filed for the purpose of defaming someone, they have any evidence to support that. Like in this case, they're saying that Kesha withdrawing her appeals after filing them, maybe that indicates that she's not really serious about the claims and that it was a sham just so she could publish in a protected way defamatory statements about the plaintiff. Because she knows that her case is going to get press, right? I don't know if it did or not. This was kind of before I had really started paying attention to. I never really paid attention to Kesha, but so I don't know if they got a lot of press. But saying someone raped me is a pretty big claim, especially today, right? And they have some statements that seem to back up that they know. We're going to go on a jihad against the studio. We're going to destroy and ruin this guy. We want to take him down. Maybe those lawsuits were shams. I don't know. But here they may lose their privilege status. So a jury will have to ask those questions or answer those questions. Let's see. The third amended complaint contains 4 causes of action. Defamation related to Kesha's assertions that Gottwald sexually assaulted her. Defamation related to a statement that Kesha made to Lady Gaga that Gottwald raped Katy Perry. Breach of the KMI agreement and breach of the prescription agreement. Kesha answered the third amended complaint and asserted 39 affirmative defenses in addition to her remaining counterclaim. Plaintiffs filed a note of issue in September 2018 requesting a jury trial. Parties now move for partial summary judgment. That was the intro. I know it was long, but we had to figure out. I didn't even know what was going on in this case, but a lot of procedural and factual background. Anon says, why do you find a video that you didn't watch to be credible evidence to suspect someone is a kitty diddler? I didn't say it was credible evidence. I never once said it was credible evidence. How is this any better than ANN? I didn't ever say that this was credible evidence. I said, here is a thing. I get it. Thank you for giving me $20, John. I get it. You're mad that someone talked about you and I talked about someone talking about you. I get it. I did not say you were a kitty diddler. I didn't say it was true. I laughed and said, you'll have to check it out and decide on your own. I don't know. I talk about all sorts of things that I know about or don't know about. And I tell people to make up their own mind. Did I say John Michael Kelly definitely did this or even probably did this? No. Go back and watch it, you piece of shit. Go back and watch the video. Or sue me, you motherfucker. Come sue me. And I will demolish you. And I'll embarrass you in front of the whole world. And then they'll all know whether or not you're a kitty diddler because we'll go for discovery on it. How's that? Try and sue me over the fact that I said, here's a thing someone made. You can go check it out if you care. Try it. Anyway, shouldn't you be better than that and verify the credibility of the accusation first? I never vouched for the credibility of the accusation. I said, here it is. Go look at it. That's all. You're making this way bigger than you need to. And you're drawing more attention to it. It was literally a one-off thing. I don't care about you. I have never cared about you. You are irrelevant to everything. Go die peacefully alone. I don't care. I don't ever want to talk about you. You're the dipshit that keeps bringing you up. John, I will not ever bring you on a show. Ever. Ever. All you had to do was just answer me when I asked who you were. You didn't. Now, I don't know if you're a kid diddler or not, so I'm certainly not going to bring you on the show. But John, I will never, ever bring you on the show. And if you don't talk to me about you, and other people don't talk to me about you, I'll never talk about you. I don't want to think about you. Just like your parents, I don't want to think about you. Nobody wants to think about you. You're a fucking roach that no one can get rid of because even though they don't care about you, you won't just go away. John, you're the stupidest fucking person on the planet. You are dumber than Shane and Ron combined. And that's an amazing multiplier of exponential idiocy. You are so stupid because you can't read and you can't listen and you draw these wild inferences about you. No one cares about it. No one cares. In fact, if I went to every newspaper on earth and said that John Michael Kelly is a pedophile, they'd all go, literally fucking who is that? Everybody. No one cares. No one. And the worst part is, I didn't even do that. I didn't do it at all. You can try and edit little clips of videos and take them out of context. You can do that all day. It will never change the fact. The video's still up and you can go look at it. And you can go listen to what I said. Now, get fucked. Oh my God. Anyways. Dear Christ. Have any of you guys had cancer? Because I think what I have is worse. Okay. Discord DMs? What about now? Hold on. All right. Since this is a topic, I'm gonna bring on someone that John Michael Kelly is mad at as me by proxy, or he's mad at this person through me by proxy. So we're gonna take 5 minutes. This is a Saturday show. We'll take 5 minutes or so, and we'll let this. Give me just a second to get this set up. Oh wait, we could just do it by audio. I don't have to. Okay. All right, 1 second here. Perception check says JMK is the herpes of the YouTube world. Once you catch him, you can't get rid of him. All right, I'm gonna bring on Spectre here, and we'll make sure the audio is coming through. Hey, man.
Hello.
Holy shit.
All right.
Hold on. 1 second. I gotta make sure your levels are good.
Okay.
Okay, you should be somewhere near me now. All right. So what's up, man?
All right. So I'm just going to address this motherfucker because apparently he has less brain cells going than a 50-year-old alcoholic who's drank 10 beers a day for the last 20 years. Motherfucker, you're pissed at me because I put it out there. I could have thrown this out there a lot sooner and just said, hey, run with it, have fun. I could have done a lot of things differently. Some better, some worse. You're pissed at Nick because Nick wouldn't give you the time of day. I told you exactly why he wouldn't. He doesn't know who the fuck you are. The only thing you could do is sound dumber than T. Greg Doucette when you were trying to say you're guilty of fucking wire fraud. You should have me on because I'm a detractor. John, no one knows who the fuck you are. Even when Gamergate Revolt... Exactly. Even when Gamergate Revolt members were trying to distance themselves from the stupid shit that people like Seattle for Truth are doing, you never got a fucking mention. And why? Because nobody wanted to be associated with you. Your parents don't want to be associated with you. No one wants to be associated with a 30-year-old college dropout who still works at fucking McDonald's and lives in his mother's basement. No one. The only fucking thing you've managed to do is piss everyone off. And you've shown you have no morals. You tried to be right wing. Now you're going for the leftists, trying to be part of Kick Vic. Kick Vic, oh, look at me. I'm managing to sound dumber than T. Greg Doucette. Look at me. I'm just so stupid. We know you're dumb. You're a fucking coward. You reported my Discord claiming that I doxed you. I didn't dox you. You never popped up at all. You are going after Nick. You reported my Twitter because you want to get rid of the fact that you're a homophobic bigot, an actual individual who called Nick's mod Keck and I'm going to use his language here, a faggot when he joined your server.
That's very homophobic of you, John. Very homophobic. Right? Oh my goodness.
Isn't that weird? But Kick Vic took you in. It's so weird. Kick Vic, the ones who say that I stand with Vic and Nick are homophobic bigots. They brought you in. And what do? You sit there like a goddamn retard, and every time you type, you can hear the drool slapping against your fucking keyboard like a waterfall. Did you remember to put on your water wings?
Did they say I'm homophobic? I love the gays.
Oh yeah. You're homophobic, and but the point of the matter is you're pissed at me for this. But guess what? I got an answer to my FOIA, or one of the FOIAs, and it's a jumbled hodgepodge with 3 contradictory answers. Now I've requested clarification, but guess what? It's been met. I'm putting the videos back up tonight, bitch. So you thought you got a reprieve. I'm just gonna put them back up. Let's see what happens. I don't really care at this point. And I want to just make this very clear. I apologize for the way I put it out. Not putting it out there because you're a fucking snake that as soon as shit gets too much for you, you're going to slither back under your fucking rock and try and make it so that nobody remembers you. Well, you don't have to do that, because even if you don't slither under that rock, nobody's going to remember you. The best thing for you to do would be to shut up and fuck off. But no, you don't. So here's what I'll do. I'll apologize. I'll apologize the minute you apologize for the gay ops for accusing Nick of wire fraud, a federal felony, of accusing Nick of being Vic Mignogna's legal counsel, an actual sanctionable, something that's sanctionable. He could put his law license in jeopardy, accusing me of aiding and abetting wire fraud, also a federal felony. Keck accusing him of aiding and abetting. Not for being the other word, because he totally is that, but that's beside the point.
Yeah, wait a minute. Keck didn't aid and abet wire fraud. It says right in the description of the GoFundMe that it will go to a Dallas area battered women's shelter, and that's what Keck is. Keck is a Dallas area battered women's shelter.
This is fair. It's going to Keck. He does act like one sometimes, but anyways. I'll apologize after you do all that. After you apologize for accusing us of being in a doxing server, of Nick running the doxing server, I'll apologize for you taking shit out of context to paint myself, Nick, other people in the I Stand With Vic sphere, if you want to call it, felons, aiding and abetting, doxers, etc. Because the only motherfucker over the many years that you've been known about in whatever twisted little world that you live in, who's been known for all of that, is you. And you can try and sit there and tell us that we're the problem. No, motherfucker. People like you are the problem. You could fuck off, die, and nobody would miss you. God, in Minecraft, of course.
I wish we ran a doxing server. That sounds like more fun.
Right? It doesn't it? I will apologize once you meet all those criterion. You won't, though, because you're so glued to this whole drama thing and getting some clout from a bunch of people who, the minute that the Vic Mignogna thing blows over, you don't matter to them. It's like with Shane Holmberg. Shane thinks he matters to them. He's gone as soon as Vic's over, because they need somebody else to look at. They need somebody else to try and go after. John, I tried to help you in August. I told you, articulate your arguments. Tell Nick who you are. And you sat there. And then in December, you reported all 15 tweets talking to you, trying to help you out. Why? Because you wanted to hide everything. You didn't want Mars Girl and Jonatello, or Manjar, whatever you want to call her. You didn't want them to know that you're a bigot. And I don't use that term very loosely. I'm okay with people. You want to say stupid shit? Fine, whatever. You don't want people to know who you are. Sure, you put in some of your videos, yeah, I'm a conservative Christian and I believe in this stuff. Nobody gives a shit. This is what you are. This is what you are. And if you didn't spurg out like a goddamn retard, if you didn't do everything in your power to piss people off, you will draw more flies with honey. But you don't listen. And all you do is needle, needle, needle. Nick probably would have had you on his show if you actually gave him a valid reason. But instead, here we are 7 months later, and what are you doing? You're still crying. And why are you crying? Because Nick has no clue who the fuck you are, and you still haven't figured that out. I'm done.
All right, buddy. Well, thanks for clarifying. What a weirdo. All right, man. Well, I'm going to get back to the show, but thanks for clearing that up. And
thank you for having me.
Yeah, no problem. We'll talk to you later.
Later.
Peace. That was Spectre. Allegedly, we'll be putting videos back up. Again, I haven't watched them. I haven't even seen them. So I'm not saying they're credible. You can determine for yourself. But let's read what Anon had to say. Because he did reply. I didn't want to break Spectre's flow, though. He seemed to be in the zone. Anon says, but you did care, Nick. No, I literally didn't. Nobody was talking about it until you made the call to action for everyone to watch the video. I did. And I'm pretty sure it was tweeted to, and Medicare had talked about it. Have you bitched at Medicare yet, John? Why not? Why aren't you bitching at Jim about it? Because I'm pretty sure when I read Gator's tweet, it was on Jim's timeline. I should ask Jim if he knows who you are. But I didn't make a call for everyone to watch the video. Watch the video if you want. Make up your own mind. Isn't a call for everyone to watch the video. It really isn't. But whatever. You're an idiot, so you're gonna read what you want. That's fine. You spread fake news to your audience and admitted to not fact-checking anything. Yes. When I said this video exists, I said, I haven't even seen it. I don't know anything about it. You can check it out and make up your own mind. I literally did admit to not fact-checking anything. That's a problem for your whole claim that I said that you did all this stuff. I don't know. I didn't watch it. I don't know the validity of it. Still don't. Never would have talked about it again. I even forgot I talked about it until you brought it up like 30 times. When you ruined an entire show on someone else's channel because you're such a salty little bitch that you had to come on someone else's channel and make the show that had nothing to do with you all about you. You spread your own anti-John Michael Kelly cancer wherever you go because you're such a victim that you have to make yourself the victim. No one would ever talk to you if you weren't like this. Which, I mean, maybe that's what you need. Maybe you need someone to, maybe you need to do this to get people to like you or something. I don't know. Don't really care. Would prefer it if you never, ever interacted with me ever again. Not because you have any valid points. You don't. That's the crazy thing. And your basic misunderstanding in your own stuff shows that you don't. That's then calm. Then calm. Raging Golden Eagle says, funny how the anime community wasn't toxic until these toxic NPCs moved into it. I try to be against gatekeeping, but these people are making a strong argument in favor of it. I won't let them influence Blade Devil. Hey, what's up, RGE? How's it going, buddy? What have you... I need to talk to you about this interspecies reviewers. This thing seems to be turning into a giant cluster. I'm going to DM you on Twitter or something. Or you can DM me. Gay and Still Large says, bet anything JMK is going to try and get his super chat refunded. So here's me paying his tab. Johnny, tell us, why does the lolly from Miss Kobayashi's Dragon Maid make you feel funny? Oh, no. Aw. And then Doom Guy sent a website. He just sent johnmichaelkellyisapedo.com. So that's from Doom Guy. Note, that's not me. I haven't been to that website. You can go check out johnmichaelkellyisapedo.com if you want on your own and make up your own mind. I have nothing to do with it. I don't endorse it. I don't say it's valid. I say nothing about it at all. It was sent to me via Super Chat, or well, Justice Chat. And by policy, I read all of them. So that's up to you. If you want to go visit johnmichaelkellyisapedo.com, it's not me calling for it. It's not on me. I didn't make johnmichaelkellyisapedo.com. I have no affiliation with johnmichaelkellyisapedo.com. I am not telling you to go visit johnmichaelkellyisapedo.com. I don't care if you visit johnmichaelkellyisapedo.com. I don't care at all. Someone else, Doom Guy, sent a Justice Chat that just says johnmichaelkellyisapedo.com. So nothing I can do about johnmichaelkellyisapedo.com. If I got a federal government demand for me to take down johnmichaelkellyisapedo.com, I'd have to reply, I apologize, sir. I have nothing to do with that website. I don't even know if it's real. It could have just been a joke. I don't know. I've never typed it into a browser. I don't know if it's a valid URL. Someone just sent me johnmichaelkellyisapedo.com. And this weirdo spurg, John Michael Kelly, seems to think that that's an endorsement. But it's not. It's just someone sending in johnmichaelkellyisapedo.com. So, I don't know what to do about that. Anyway, Tofu Hazard sent a thumbs up. Hey, thanks, buddy. And Nix Hex says, kind of random thing I haven't heard in a while. But what even is an anime community? Does it actually need healing? Does anyone outside of Twitter even know who Vic, Monica, etc. are? I don't know. I don't know what the anime community is. Beside the fact, I think that's just people who watch anime, but that's too broad. But that's like saying America, right? Like the American community, and then you've got states and cities and municipalities and all of that stuff. And you break down communities smaller and smaller. So the anime community is this broad, ephemeral thing where there's just a bunch of people who like anime in some way. But then there's more concentrated communities, cosplay or convention communities. There are artist communities. You know, heck, even subs versus dubbed anime is probably a community. As for does it need healing? I think a section of it does. Because there's a breakdown. And the breakdown is unfortunately led by people lying, right? There's people lying about Vic. There's people lying about what standards there are in the industry. There's people lying about basic human interaction. All of that stuff is crazy. I mean, I was thinking of a joke, and this might be demeaning, but I don't mean it to be demeaning. I don't mean it to be demeaning at all. But I was thinking about this joke earlier, and so these people are out there claiming that Vic was having inappropriate encounters with fans or whatever, and of some sort of sexual nature, maybe like sexual innuendo or whatever. And then we've got the picture of DC Douglas like grabbing a woman's breasts, right? Like I tweeted that out on Twitter today. Earlier, I retweeted it or whatever. That picture was just, I don't know, picture of him grabbing a woman's breasts. Here's the thing. Like, are we going to pretend that in the anime convention community, there aren't awkward sexual encounters? That's not like a part of the magic? Like, not to be cruel, but like there's this weird... Anime conventions have this weird sexual tension. I mean, cosplay tends to be very revealing. That's been like a running gag. It's people who some people are socially adept and some people are socially stunted, just like in every other community, right? Just like everywhere. But conventions that let people come together into a place and bond over commonality that they might not be able to easily find in their normal spheres, breeds awkward, sometimes sexually charged encounters. It's a kind of a weird thing, but it exists. It's been a joke for a very long time, or more of a meme, less of a joke. But before ever going to an anime convention ever, there was this murmur about the underlying sexual activity. Or at least sexual tension in the whole thing. So I don't know why we're all pretending that this isn't a thing that's been going on forever, and that these encounters are somehow strange or out there. Sakaki Onsai says, enough about JMK and his nutmegs. How awesome is it that Kitchener Comic-Con has been getting a crap ton of love from the anime and convention community in the face of some blue hair idiots trying to cancel them? Hashtag for the fans. Hey, Kitchener is great. I am very excited to go to Kitchener Comic-Con. There's one person I know who won't be there, and that'll be funny. But no, I'm just kidding. There's a whole bunch of people who won't be there. But I am so excited to meet any and all of you who are able to make it. So come seek me out. Come watch my stupid panels. I don't even know when they are yet. But yeah, come hang out. Let's have a good time. We can get drinks after or whatever. I'm a night owl, so I'll go later in the convention, and let's have a good time. Please say I notice you, Caleb Senpai. I notice you, Caleb Senpai. Sounds good, Chris. Sounds good. Okay, can we get back to this stupid Kesha document? Let's do that. Here we go. Summary judgment may only be granted if there are no material disputed facts. The moving party bears the burden of making a prima facie showing of entitlement to summary judgment as a matter of law. Failure to make such a showing requires denial of the motion regardless of the sufficiency of the opposing papers. If a prima facie showing has been made, then the burden shifts to the opposing party to produce evidence sufficient to establish the existence of a material question of fact. The evidence must be construed in the light most favorable to the opposing party, and the motion must be denied if there is any doubt as to the existence of a triable issue. So, summary judgment exists for one main purpose. Juries and judges are fact finders. Oh, I'm not showing the document. Thank you. Juries and judges are fact finders. Their job is not to determine anything other than find out the factual story that's true and then apply the law to the facts. That's it. Sounds really easy, but it's not. They have to determine, that's why they're weighing evidence and taking all testimony, trying to find the best truth that's out there, right? The most likely to be true on the most issues as they can. Well, summary judgment then says, okay, well, we agree, this party and this party agree on these facts. Therefore, since we agree on the facts, there's no need for a jury or a judge. We have the facts. All we need now is the legal conclusion as applied to the facts that exist. That's it. So that's what summary judgment exists for. Mere conclusions, unsubstantiated allegations, or expressions of hope, however, are insufficient to defeat summary judgment. All right, defamation. X the Eliminator says, when you're hated so much, people are willing to pay you for it. Nick Rekieta equals best heel. Well, yeah, he also pays to be in my Discord. He should just talk in the Discord, as opposed to like hiding. I don't know why he doesn't. He pays for it. He should talk. Maybe he doesn't have any hands because of the coom. Defamation is publication of a false statement about a person tending, quote, to expose the plaintiff to public contempt, ridicule, aversion, or disgrace, or introduce an evil opinion of the plaintiff in the minds of right-thinking persons, and deprive that individual of friendly intercourse in society. A defamation plaintiff must establish that a false statement was published to a third party without privilege or authorization and that it caused harm, unless the statement is defamatory per se, in which case it is actionable regardless of harm. A false accusation of rape, a serious crime, is defamation per se. Here's the statements that Gottwald drugged, raped, and sexually assaulted Kesha. By the way, sexual assault is rape in some states. Like Texas. Oh my goodness. I have got a baby who will not go to bed. Just a second. Oh my goodness. Okay. back to I have a feeling I'm going to be getting up in another 15 minutes or so. All right, statements that Gottwald drugged, raped, and sexually assaulted Kesha. Both parties move for partial summary judgment on legal issues that will narrow the scope of the trial. In seeking only partial summary judgment, they acknowledge the obvious, that this case cannot be finally resolved without an assessment of credibility. It will be incumbent on a jury to decide what has been sufficiently proven. If the jury ultimately finds that statements Kesha and her agents made are not false, she cannot be liable for defamation under any circumstances, and the defamation-related issues that follow would be academic. So proof of fault. Actual malice and gross irresponsibility. Scroll up to Marie Teach comment about her reporting you. I didn't tell him to kill himself. I said to go die peacefully alone. That's different than killing himself. Oh my goodness. Ah, you people. You people. Defamation jurisprudence. Okay, so proof of fault is actual malice and gross irresponsibility. Defamation jurisprudence has evolved from the tension between balancing the First Amendment's right of freedom of speech with protecting an individual from harm caused by dissemination of damaging false information. To ensure robust discourse about certain matters without fear and prior restraint, courts have adopted certain safeguards applicable under certain circumstances. Not all false statements are actionable. Though some proof of fault is required, states are generally free to define the appropriate standard of liability for defamatory falsehoods related to private individuals, even if the statements relate to a matter of public interest. Oh my goodness. The United States Constitution, however, mandates more latitude for false statements related to public figures who are less vulnerable because they, quote, usually enjoy significantly greater access to the channels of communication and, quote, have a more realistic opportunity to counteract false statements than private individuals normally enjoy. To recover for defamation, a public figure must not only establish that false statements were made, but must also prove by clear and convincing evidence that they were communicated with actual malice, that is, knowledge or reckless disregard of their falsity. Public figures are those who have assumed the roles of special prominence in the affairs of society. This is more from Gertz versus Welch. Karma K says, Nick, at what point will you take responsibility for your sloppy journalism? Seems like you don't care about the damage to anyone's reputation except Vic's. Also, you should let JMK on because you had his accuser on. So John Michael Kelly has gone to create another account now. Oh, okay. John, I will never have you on. Ever. I'll have every one of your accusers on before you. And then I won't have you on. You blew the chance. You blew it. You don't have a right to my show. Ever. You never did. You could have asked a long time ago. You didn't. You didn't ask. You demanded a spot. You demanded me to respond to someone. Now, you can send all the super chats you want. I won't turn them down. I will read them, but I will no longer respond to obvious super chats by you, no matter how many sock puppet accounts you create. So, you can send them all. Actually, no. If you send $100 one or more, I will respond. There you go. But if you send under 100, I'll just read it. All right. All right. Few people attain positions of such pervasive power and influence that they are deemed public figures for all purposes. More commonly, those classified as public figures have thrust themselves to the forefront of particular public controversies in order to influence the resolution of the issues involved. Kesha urges that Gottwald is a public figure and can only recover for defamation if statements asserting that he drugged, raped, and sexually assaulted her were made with actual malice. Gottwald certainly is not a general public figure. Although he may be well known in music industry circles, He has never been a household name or achieved general pervasive fame and notoriety in the community. So here we have that note about general purpose public figures. And here we have a guy who is, he's a producer in the music community. He's a professional. He's runs a record label. He's signed Kesha, and he signed Kesha 10 years ago. So this is, we're talking about Kesha has become, as alleged by both Kesha and the plaintiff, apparently, she is quite popular at this point. She might actually be a household name. He works with her. He actually apparently recorded or produced at least 6 of the tracks on each of her album, according to their contracts. So, this is a guy who's no slouch in the music industry, and he has a stupid name. That being said, the court still says people don't know who he is in any, not a household name. Nobody knows who this guy is. Nor is he a limited purpose public figure. A person is a limited purpose public figure, quote, regarding a particular issue or subject when he or she voluntarily injects him or herself into a public controversy with a view toward influencing it. Gottwald did not thrust himself into the vortex of the public issues or engage the public's attention on the important public matters implicated by the defamatory statements. Public controversy alone insufficient. Plaintiff must assume special prominence in resolution of public questions. Plaintiffs must be more than tangential participants in the controversy. They must have achieved special prominence in it, and either one must purposely try to influence the outcome of the public controversy, or two could realistically have been expected because of their position in the controversy to have an impact on the resolution. In action related to statements about his medical license, plaintiff was a public figure due to, among other things, his more than 100 television appearances as a medical expert. Plaintiff, who projected his name and personality before millions of readers and viewers to establish his reputation as a leading authority on professional football, was a public figure defamation plaintiff as to statements denigrating his professional abilities. Lots of citations here. Plaintiff welcomed publicity regarding her performances and therefore must be held to be a public figure with respect to newspaper accounts of those performances. So see, there's a difference here. Question is not whether or not you inserted yourself into the public discussion. It's about whether or not you insert yourself into the public discussion relating to the defamatory statements and their character. So for limited purpose public figures. Let's see. Plaintiff, through publication of countless articles on whether HIV causes AIDS, projected her name and personality to establish herself as a leading authority, was a limited public figure with respect to statements discrediting her research. Physician who invited favorable publicity for practice by appearing on television to discuss medical procedures, was a public figure plaintiff in defamation action related to broadcasts about whether he performed unnecessary surgery. Status as an executive within a prominent and influential company does not by itself make one a public figure. Plaintiff's role as an activist in public controversy concerning unit pricing, open dating, the cooperative form of business, and other issues rendered him a limited public figure in action related to a statement about whether his business lost money and was retrenching. So the questions that the court will have in Vic's case, if this were still to be decided, if the appeals court is going to take a look into the public figure versus private figure status, they will have to argue, and I don't know that they can revisit this issue without the appeals court overruling Chubb, or at least remanding that issue back to the court for further decision. Either way, if they do remand it back to Chubb and say we need to resolve the public figure question, then what will have to happen is the court will have to determine, based on Vic's limited amount of statements that he did make, and these would be the apologies. These would be any apologies or statements at cons relating to the case up to the time he filed the lawsuit. They'll have to determine if those statements are enough attempts to influence on the subjects of the defamation to make him a limited purpose public figure. This is another reason you don't ever apologize. Don't do it. Tucker says, I'm perfectly happy with burning down the whole anime community here in the West, burn it down and rebuild it from the ground up, this time without the danger hairs. Okay. What messages are getting deleted? Oh, man. Hey, Siren, please only time people out if they are spamming, please. People are allowed to say their inanities. That's okay. Even if it's a death threat. If it's not a death threat, it's a death suggestion. So even if it's a death suggestion, they're allowed to say them. So that's okay. I mean, I don't care. So I'm not asking anybody to be shut down at all. Only please suspend people if they're spamming, because that's the rule. Okay. Though Gottwald has sought publicity for his label, his music, and his artists, none of which are the subject of the defamation here, never injected himself into the public debate about sexual assault or abuse of artists in the entertainment industry. Footnote. Defendant's reliance on Mall, for example, is misplaced because in that case, there was a close nexus between the defamatory statements and the purposeful activity undertaken by the plaintiff to thrust himself into the public eye. The alleged defamation in Mall denigrated the plaintiff's writing abilities and the product of his craft. His books, articles, and personal appearances were obviously designed to project his name and personality before millions of readers and television viewers, and to establish his reputation as a leading authority on professional football. He not only welcomed but actively sought publicity for his views and professional writing. Same is true of the other cases defendant cites. The defamatory statements at issue here, by contrast, are wholly unrelated to any purposeful activity undertaken by plaintiffs. So again, that would be the question, is whether or not the statements that Vic has made are him thrusting himself into the public. I would suggest no. Court may disagree, of course. And I'm sure other people will disagree, and that's okay. I can certainly see where the court would say yes. I would argue no, because his statements were merely responding specifically to the harassment from the other parties, and that actually be interesting. He could say his statements weren't related to the party's statements at all. I think he might have, according to Ron, he made them before the parties said anything, but who knows? We'll have to see. All right. The only reason Gottwald has any public connection to this issue raised in this lawsuit is because they were raised in the lawsuit. That cannot convert him into a limited public figure. Public figure inquiry focuses on plaintiff before defamation was published. Otherwise, press could convert a private individual into a general public figure simply by publicizing the defamation itself and creating a controversy surrounding it. See, defamation defendants cannot, by their own conduct, create their own defense by making the claimant a public figure. And again, that may actually be what happened in Vic's case as well. Because Gottwald is not a public figure for purpose of determining the constitutional protection afforded to statements by Kesha that he drugged, raped, and sexually assaulted her, the actual malice standard is inapplicable. Plaintiff need not prove gross irresponsibility under these circumstances either. The grossly irresponsible standard by its terms does not apply to a first-hand account of events not involving any media publication, investigation, or news gathering. Where the content of the article is a matter of public concern, a party may only recover after establishing by a preponderance of the evidence that the publisher acted in a grossly irresponsible manner without due consideration for the standards of information gathering and dissemination ordinarily followed by the responsible parties. Okay, so liability for statements by alleged agents. I'm not going to read the footnote on this because it's just cases on that standard which they said didn't apply. Liability for statements by alleged agents. Kesha pleads that she did not authorize, direct, or have knowledge of statements made by others and therefore cannot be liable for them. A party authorizing others to speak on its behalf can be held vicariously liable for defamatory statements made by its agents. At issue is whether, as a matter of law, Kesha should be held liable for statements that her press agent, lawyer, mother, and Michael Eisel, organizer of the Free Kesha campaign, made. So they have to determine if these agents had a sufficient agency relationship to hold her vicariously liable. Catch you later, Gelf. You want to be a mod? I'll make you a mod. There you go. You're a mod. Press agent. A week before the California action was commenced, Mark Garagos retained Sunshine Sachs to provide public relations services for the exclusive benefit of Kesha. Sunshine Sachs' very job was to speak on Kesha's behalf. Indeed, the only reason Sunshine Sachs made any of the statements or formulated the press plan was because Kesha paid it to do so. As a matter of law, if plaintiffs prove that Sunshine Sachs' statements were defamatory and a privilege does not apply, then Kesha will be held vicariously liable. Kesha's lawyer. Same is true for Garagos' statements. As Kesha's lawyer, Garagos was her agent with speaking authority. He filed the California complaint that is alleged to be a sham and the catalyst for Kesha's publicity campaign on Kesha's behalf. He spoke to the media on Kesha's behalf. To avoid liability based on Garagos' statements, Kesha invokes her retainer agreement, which sets forth that attorney will not engage in any publicity without her prior approval, including without limitation making public statements, issuing any press releases, or engaging in any interviews with members of the press. She swears that she did not review or receive the press plan itself or know that the strategy memorandum was prepared, and that she did not authorize, direct, approve of, or have advanced knowledge of Garagos' particular public statements that are on the subject of this suit. Kesha does not, however, deny that Garagos was authorized to hire Sunshine Sachs as a press agent on her behalf, or that she gave him approval generally to handle publicity, make public statements, issue press releases, and conduct interviews with members of the press, all of which he did regularly and starting from very early on. Lack of prior knowledge and individualized approval of the particular details or specific contents of the statements does not make them unauthorized. Significantly, there's no evidence that Kesha ever stopped Garagos from engaging in these usual activities to further her cause. There can be no doubt that Garagos' media communications were generally foreseeable and undertaken for her benefit, not for personal motives unrelated to the furtherance of her interests. So there you go. That's on the matter for Garagos. Even if Garagos breached the retainer agreement, and there's no evidence that he did, it would not alter the analysis because the principal is liable for its agent's acts when the conduct is generally within the scope of the agent's authority. This is, of course, why Kick Vic wants so desperately for me to be an agent of Vic. So that's, there you go. P.B. Siebert and Michael Eisel. In contrast, there can be no matter of law determination that either P.B. Siebert or Michael Eisel were Kesha's agents when they made statements about Gottwald, because there's no signed agreement. There's no agreement at all. It's unclear whether Kesha's mother, P.B., was acting as her daughter's agent when she sent the December 2013 email. Although Kesha's attorney asserted that P.B. sent the email as Kesha's agent, that informal judicial admission is not dispositive. Indeed, Kesha adduces evidence that her manager asked her mother to stop and that P.B. may have had her own independent motives for her statements. She sufficiently raises issues of fact as to whether her mother was acting on her behalf and whether she was authorized to speak for her. So this is going to defeat summary judgment for Kesha's mother, for the statements made by Kesha's mother. They can still be adjudicated by a jury. It's just now a fact question for a jury. Similarly, there are questions of fact about whether Eisel was Kesha's authorized agent. Kesha and Eisel were in direct communication concerning Kesha's claims about Gottwald. Eisel disseminated these allegations in public and online as part of the Free Kesha movement, often using Kesha's own words. Kesha, who gave Eisel gifts and paid for his hotel room so that he could protest her treatment, requested that Eisel post information online, and Eisel eagerly complied. Kesha even told Eisel to delete their text messages because, quote, it just can't seem we are as close as we are. This evidence could support a reasonable conclusion that Eisel was part of Kesha's public relations strategy and served as her agent. Whether Eisel took direction from Kesha when he communicated the allegedly defamatory statements, or whether he was independently inspired by her, is a question for the jury. So there you go. The admission was made during Miselis' deposition for the express purpose of invoking the attorney-client privilege, so that plaintiff's counsel could not ask Miselis about his communications with P.B., who is not his client. Kesha is now walking back that admission, thus her privilege objection is no longer viable. Affirmative defenses to defamation. So here we have affirmative defenses. All right. Parties move for summary judgment on several of Kesha's defamation-related affirmative defenses. Protected opinion and rhetorical hyperbole. Both parties move for judgment on whether, as a matter of law, 18 statements constitute protected opinion or hyperbole that cannot be actionable. Kesha contends they are, and plaintiffs maintain they are not. Defamation claims may only be predicated on false factual statements. Because opinions cannot be proven false, they do not give rise to liability. Whether a statement is one of opinion or objective fact is a question of law. Statements as at issue assert, as a matter of fact, that Gottwald drugged and raped Kesha. They're undoubtedly factual because their precise meaning is clear and unequivocal. Gottwald drugged and raped Kesha. Statements can be proven true or false because Gottwald either drugged and raped Kesha or he didn't. The overall context of the statements, moreover, is unmistakably indicative of factual assertions. After all, Kesha sued Gottwald for, in fact, drugging and raping her. She wanted to be released from her contracts with plaintiffs because she maintains that Gottwald did drug and rape her. She hired Garagos to pursue justice on her behalf because she asserts that Gottwald drugged and raped her, not simply because those events may or may not have happened in her opinion. So these are factual statements. Again, you'll notice some similarities. Some of the defendants. This thing did happen. Monica's story is a bunch of factual statements. Not an opinion on whether or not she believes she was assaulted, right? Jamie Markey's story is not an opinion on whether or not she believes Vic grabbed her hair forcefully, drug her head into his chest, and whispered something sexual into her ear. Those are fact statements. Only contested affirmative defenses that have not already been addressed are analyzed in this decision. Kesha's affirmative defenses that the claims are barred by a statute of limitations, have been pled insufficiently, are rejected for the reasons set forth in the August 2018 decision. Amendment would not have been allowed had the claims been beyond the statute of limitations or inadequately pleaded. Kesha does not oppose dismissal of her libel-proof plaintiff affirmative defense. So she ran with libel-proof as well. Good job. Is there a something sexual shirt yet? No, there's something sexual towels and stuff like that. I think my man was making listings, not overview. Making something sexual shirts, but they're not up yet. Okay. All right, so that's not there yet. Dang. Sorry. All right. Almost each and every statement that is the subject of Kesha's summary judgment motion explicitly refers to Gottwald drugging, raping, or sexually assaulting her. To the extent that a few of these statements do not contain express references to rape or sexual assault, summary judgment still cannot be awarded on this record because the statements which infer to or imply physical abuse are still potentially susceptible to a defamatory meaning if a jury were to find that the speaker was referring to the alleged rape. It is questionable whether these particular statements matter to Gottwald, considering that the explicit statements and allegations alone were likely enough to have caused all of the alleged damage to his reputation. On this record, the court cannot rule out liability as a matter of law. Okay, so they're saying that they can only rule on the definitive statements that this happened in favor of Gottwald. On the other statements, they can't rule on summary judgment. They'll have to go to a jury. They're undoubtedly factual because their precise meaning clear and unequivocal. Oh, yeah. The statements can be proven true or false because Gottwald either drugged or raped Kesha or he didn't. Wait, I read all of this. She hired Garagos to pursue justice on her behalf because she asserts that Gottwald drugged and raped her, not simply because those events may or may not have happened, in her opinion. For the same reasons, none of the statements qualify as rhetorical hyperbole. Each statement conveys exactly what its speaker intended to convey. Gottwald drugged, raped, and sexually assaulted Kesha, and is a criminal for doing so, like Bill Cosby. In the context of this litigation and of her very serious assertions, Kesha cannot be suggesting that the statements are not factual or are exaggerations. Kesha's belief that a litigation privilege applies to allegations in her California complaint and to statements related to litigation does not render the statements non-factual opinions. Footnote. Even equivocal accusations, unlike the ones here, can be deemed statements of facts. Quote, a reasonable listener would have understood that defendants intended to label plaintiff as a child rapist, hence the statements would be actionable even if they were couched in the form of an opinion. I think plaintiff sexually assaulted my child, rather than fact, plaintiff sexually assaulted my child. So there you go. Litigation privileges. Kesha moves for summary judgment dismissal of the defamation claim as to certain statements, arguing that there can be no liability because, quote, it is undisputed that they were made during settlement discussions as pertinent to good faith anticipated litigation by Kesha in litigation filings or by Kesha or her attorneys to contextualize litigation developments. That's to account for 27 of the statements. Ordinarily, statements made during or in connection with good faith anticipated litigation are privileged and cannot give rise to defamation liability. Here, however, there are sharply disputed questions of fact going to the heart of the case about whether Kesha's California complaint was brought in good faith, as Kesha asserts, or whether it was a sham intended to defame and pressure plaintiffs, as plaintiffs assert. So there's a material fact that's in dispute. Were these statements made with good faith litigation in mind, or was the litigation a sham? Kesha and Gottwald have very different accounts about what happened on the night at issue. This court cannot decide as a matter of law on papers and without any assessment of credibility who should be believed and whether Kesha commenced the California action, which she would not have done if she had been released from her contracts, in good faith or as a sham to defame Gottwald and obtain business leverage. That decision is for the jury. So any of the statements about Kesha being raped by Gottwald, they're not being ruled on as a matter of summary judgment. They're going to go to jury trial. Statement that Gottwald raped Katy Perry. Plaintiff's motion for partial summary judgment on elements of their defamation claim related to Kesha's statement to Lady Gaga that Gottwald raped Katy Perry is granted. So here's where Gottwald wins against Kesha on summary judgment. Plaintiffs met their heavy burden of establishing entitlement to judgment that Kesha published a false statement about Gottwald to a third party that was defamatory per se. Kesha admits that on February 26, 2016, she texted Lady Gaga that Katy Perry was raped by, quote, the same man, referring to Gottwald. Plaintiffs submitted evidence that Gottwald did not rape Katy Perry. Perry unequivocally testified that Gottwald did not do so. In response, Kesha has not raised a triable issue. There's no evidence whatsoever that Gottwald raped Katy Perry or that Katy Perry, whose sworn testimony is unrefuted, must not be believed. There's a footnote down here. Kesha's argument that plaintiff cannot obtain partial summary judgment on certain elements of a claim is rejected. Kesha herself seeks partial summary judgment on certain elements of plaintiff's claims. In any case, the rule expressly permits summary judgment on a cause of action or part thereof. So yeah, they can get it. Plaintiffs do not seek summary judgment on the without privilege or authorization element. Okay. So Kesha cannot defeat summary judgment with mere speculation. Once a movement meets its burden, it is insufficient to merely set forth averments of factual or legal conclusions, and evidence must be proffered in opposition. So she would have to show, once Katy Perry comes out and testifies, he never raped me, suddenly we have a lie, right? We have a lie, and unless she provides some evidence that Katy Perry said she was raped or told Kesha or something like that, some reason for her to believe the statement is true, that would be some sort of counter evidence that could have been brought. And they didn't raise it. They didn't raise it at all. Moreover, publication of a false statement to even one person, here Lady Gaga, is sufficient to impose liability. Defamation requires but one communication to a single person. That the defamatory statement was only shared with 3 people who were plaintiff's family members is not a basis for dismissal. Communication to even one person other than the defamed is sufficient. A breach of contract. Courts are not free to, after the fact, alter agreements that the parties reach to reflect personal notions of fairness and equity. To ensure stability in the law and provide guidance to parties weighing the risks and advantages of entering in a binding agreement, settled rules must be neutrally applied. Absent extraordinary circumstances, parties are held to the agreements that they make. Plaintiffs move for summary judgment on Kesha's counterclaim, which seeks declaratory judgment that the KMI agreement has been terminated and Kesha has replaced KMI as a party to the RCA agreement. Their motion is granted. Termination based on election of remedies. Kesha seeks a declaration that the KMI agreement has been terminated based on KMI's election to sue for damages rather than specific performance and his failure to perform. She maintains that by suing her for breach and seeking damages, KMI elected its remedy and waived the right to further enforce the agreement. Okay, so what she's doing here is when you sue for breach of contract, you can either sue for damages or you can sue for performance. Typically, the court will enforce performance. The problem is when you have a highly specialized sort of talent, a particular artist, for example, there isn't an alternative performance that can be done, and the performance that you get may not be satisfactory, right? If your contract is to have Kesha doing tracks on an album, you can't put somebody else in Kesha's place. I mean, we could pedantically argue about whether or not Kesha is replaceable, but I mean, like if you're trying to get a particular artist, another artist simply won't do as a substitute. And if that artist is trying to perform under duress, they may not perform very well. It's not a task that can be assessed on its quality like building a building, right? Contractors have building codes. So if you sue a contractor for performance, contractor has to put up the building and it has to be up to code within the professional standards of building a structure. There is no professional standard for music. We know this because of modern music. There's no professional standard for it at all, and there's no way to enforce that performance requirement. So when you have these highly specialized party-dependent contracts, what you end up doing is suing for damages because there is no replacement that is sufficient. So there you go. She maintains that by suing her for breach and seeking damages, they elected its remedy and waived the right to further enforce the agreement. That argument was already rejected in the April 2016 decision because nothing precludes a party from affirming the existence of an ongoing contract and suing for damages owed while the agreement remains in full force and effect. A breaching party, for example, cannot escape its future contractual obligations by deeming the contract terminated after it has violated provisions of the agreement and the non-breaching party has sought redress through the courts. Placement of KMI as a part of the RCA agreement. Oh, let's read the footnote. Kesha also maintains that by refusing to renegotiate her contract and verbally and emotionally abusing her, Gottwald breached the KMI agreement's implied covenant of good faith and fair dealing and terminated the contractual relationship. The court, however, has already rejected this argument. Additionally, the implied covenant cannot be used as a vehicle to add terms to the parties' contract that they did not expressly adopt, particularly where, as here, the parties agreed that no additional representations were made. Nothing in the parties' agreement legally obligated renegotiating of the existing contract. Okay. Kesha also maintains that by Paragraph 3 of the assent provides, if during the term of the RCA agreement, KMI for any reason ceases to be entitled to Kesha's services, or the results of Kesha's services as the artist in accordance with the terms of the RCA agreement, or KMI for any reason fails or refuses to furnish to RCA Kesha's services, or the result of Kesha's services, in accordance with the terms of the RCA agreement, Kesha will be deemed substituted for KMI as party to the RCA agreement, and she will render such services and perform such acts as will give RCA the same rights, privileges, and benefits it would have received under the RCA agreement had KMI continued to be entitled to Kesha's services and the results of Kesha's services as the artist in accordance with the terms of the RCA agreement. Such rights, privileges, and benefits will be enforceable in RCA's behalf against Kesha. So if this entity dissolves or goes away, Kesha's still on the hook. She doesn't get to just fold the entity and come back, or someone else doesn't get to fold the entity and release her from her obligation. Kesha maintains because there are tribal issues of fact as to whether KMI has ceased to be entitled to her services, given Gottwald's implied covenant breach, and as to whether KMI for any reason failed to furnish Kesha's services in accordance with the terms of the agreement, summary judgment must be denied. She maintains that KMI's failure to meet delivery requirements under the RCA agreement was not because of her failure to perform, but rather because of Gottwald's unreasonable refusal to renegotiate and pattern of abuse. There are no questions of fact as to whether Kesha was actually deemed substituted for KMI, or whether she's entitled to be deemed substituted for it under the assent. KMI did not cease to be entitled to Kesha's services as a matter of law, and subsequent to interposition of her counterclaim, Kesha delivered 2 albums. RCA, moreover, has not complained of any breach of the agreement and has deemed the relationship a success. There's no basis for Kesha to invoke a breach of the RCA agreement that would allow her to be deemed KMI's replacement. Her counterclaim thus fails. So, there you go. Pre-judgment interest on late royalty payments. In their third claim, plaintiffs allege that the KMI agreement entitles them to unpaid royalties due within 45 days of Kesha's receipt of certain ancillary income and unpaid tour receipts payable within 30 days of the end of the applicable tour cycle. They allege that Kesha must pay damages plus interest for her breach. Kesha does not dispute that she did not pay any royalties to KMI between January 1st, 2012 and December 31st, 2016. It is further undisputed that on August 7th, 2017, well beyond the deadline set forth in the parties' contract, and after this action had been commenced, Kesha finally paid $1,302,043.41 in royalties for this period. Plaintiffs accepted the payment but expressly reserved the right to seek an award of prejudgment interest on the entire amount Kesha withheld for years. Plaintiffs now seek summary judgment on the interest due for the belatedly paid amount. They propose an intermediate date for assessing the interest owed each year, and based on CPLR 5001, calculate the interest due as $373,671.88. Whew, that's a lot. Kesha does not dispute the terms of the contract or calculation of the interest. She urges that because there's been no finding of breach, there's no predicate for an interest award. She maintains that the payments of over $1.3 million with checks endorsed Dr. Luke commission payable as of 12/31/16 were simply a good faith gesture to resolve a dispute without troubling the court. Nope. Okay, what she's referring to, or what they're trying to refer to, is a full faith and satisfaction. A full faith and satisfaction is a clause you can add to a check or other payment note. When you are paying somebody, you can say, write a check for an amount less than what you owe, and say something like, for full faith and satisfaction of all claims related to X on the check. And if they accept it and cash the check, you win. You don't owe them anything anymore. Now, this is not as simple as it sounds, but it sometimes is. When it's one person to another person, it's one check written to another. Yeah, you can resolve debts this way. You can pay less than what you owe with the little label for full faith and satisfaction of debt owed for car purchase, for example. Something like that. If they accept it, they're bound by that because they accepted it. If they didn't want to accept it, they could return the check. Simple. This gets muddy when you're dealing with like financial institutions, for example, because certainly not because financial institutions hold inordinate amounts of power, lobbying power over lawmakers, including the lawmakers' very bank accounts, but really because financial institutions, or like a place like Walmart or whatever, they accept hundreds of thousands of checks per day, and they are not examining each check individually upon their acceptance. Should that be an excuse? No. Is it an excuse? Yes, often. So it doesn't always work when you're dealing with a big company, but person to person, you can resolve these things this way. You should, of course, consult a lawyer in your jurisdiction to see if that will work for your particular situation. All right. She also contends there remain tribal issues of fact for the jury to resolve, that the parties altered or waived the timeframes for payment, that there should be an offset for monies owed to her. Those arguments are rejected. Kesha again asserts that plaintiffs cannot maintain a breach of contract claim against her because Gottwald breached the parties' agreement. That argument, however, has been rejected. By making the August 2017 payments for commissions as of 12/31/16, Kesha conceded that she owed those amounts. In fact, even now, she does not dispute that the KMI agreement entitled plaintiff to those sums that she paid late, nor does she show that plaintiff's timeframes and interest calculations are incorrect or otherwise challenge them. For arguments that the parties modified the time for payment despite the absence of any written agreement, and that there was an ongoing waiver of timely payment by plaintiffs, is not countenanced by the KMI agreement, which contains no oral modification and no waiver provisions. So they have provisions in the contract that says this is the full agreement. No other provisions can modify this agreement without an express written consent of both parties, typically is what they would have. I don't know if it's in here or not. But they would say, only a subsequent writing signed by both parties will be acceptable to modify the material terms of this agreement. Plaintiffs have proven that they were entitled to the over $1.3 million that Kesha paid belatedly after this lawsuit was commenced. There's no legal basis for absolving her of paying statutory prejudgment interest on that amount. So there you go. Because plaintiffs demonstrate that Kesha breached the KMI agreement by not timely making payment, prejudgment interest on the delinquency is mandatory. As Kesha has not raised any issue related to the reasonability of the proposed dates of accrual of prejudgment interest or its calculation, judgment is awarded to plaintiffs in the amount of $373,671.88. Ouch! Affirmative defenses to breach of contract. Plaintiffs moved for summary judgment on several of Kesha's breach of contract related affirmative defenses. The only two that have not already been addressed that Kesha contests are unconscionability and fraudulent inducement. Those defenses fail as a matter of law. So here we go. Plaintiffs move for judgment on 5 affirmative defenses: statute of limitations, impossibility, California 7-year rule, unconscionability, and fraudulent inducement. Kesha concedes dismissal of the first and third of these defenses by failing to address them in opposition. To be sure, Kesha is alleged to have begun breaching the KMI and prescription agreements in 2013. This action was commenced in 2014, well within the applicable 6-year statute of limitations. The impossibility and 7-year rule affirmative defenses were previously rejected. So this is a lesson that if you don't address the affirmative defense in your response to the summary judgment, you're going to lose it. Okay. A determination of unconscionability generally requires a showing that the contract was both procedurally and substantively unconscionable when made. There must be an absence of meaningful choice on the part of one of the parties, together with contract terms which are unreasonably favorable to the other party. Neither factor is present here. At the time of contracting, Kesha was represented by counsel, and nothing compelled her to enter into the agreements. Contractual terms, moreover, as acknowledged by Kesha's expert, are typical in the music industry between producers and fledgling artists, and nothing authorizes invalidating the bargain that the parties struck after weighing their options and making informed, counseled choices. So there we go. We've got Kesha's own expert says, no, these are normal terms. Whoops. Fraudulent inducement. Kesha's claim that she was fraudulently induced to enter into the KMI agreement based on Gottwald's promise to renegotiate the contract if her first album was successful is not viable because a fraud claim cannot be predicated on a promise of future performance. Kesha does not claim that Gottwald misrepresented any then-present facts. To the extent the fraud is based on Gottwald's future promise being insincere, the lack of proof of scienter is fatal. Where fraud claim is based on an alleged false promise, the plaintiff is required to plead specific facts from which it may be reasonably inferred that the defendant did not intend to keep the promise when it was made. In opposition, to plaintiff's motion, Kesha does not cite any evidence of Gottwald's insincerity in 2005. The mere fact that the express performance was not realized is insufficient to demonstrate the defendant falsely stated its intentions. You have to show something contemporary to the signing of the agreement that the agreement was false. All right. Only a couple pages left, and then we're done. So footnote, California 7-year rule, which does not apply because New York law governs, does not render the agreements unconscionable. Unconscionability, moreover, is analyzed as of the time the contract is made. No authority that an agreement can become unconscionable due to subsequent events. Additionally, the KMI agreement sets forth that no one made any promise, representation, or warranty whatsoever, express or implied, oral or written, not contained in the contract itself, and that all understandings and agreements between the parties were merged into the contract, which fully and completely expresses their agreement. Read your contracts, guys. I can't say it enough. Read your contracts. If you have a contract, many of them are going to have this sort of language. This contract fully and completely expresses their agreement, or this contract is the full expression or full manifestation of the agreement between the parties. Read it, and when you read that line, go back and read your contract again and make sure that everything that you want in there is in there and everything you don't want in there is out. You have to do this. Because once that clause is binding 99.9% of the time, it says that everything that you want in there is in there. I've seen people get burned by this a lot. They negotiate things out orally, and then they get a contract that's a form agreement that doesn't have those special oral agreements in it, and they get burned on it. Don't get burned on it. You should be reading your contracts 3, 4, 5, 6 times critically. You should take breaks between reading them. Take your time. Have someone else read them. Have other parties read them. Make sure you got it. Kesha therefore cannot reasonably rely on any promise of future performance that was made before the agreement was signed, but not included in the final contract. Accordingly, it is ordered that plaintiff's motion for partial summary judgment is granted to the following extent. Garagos and Sunshine Sachs were Kesha's agents when they made the subject statements. Kesha's sole remaining counterclaim for declaratory judgment is denied, so she has no counterclaims left. KMI is entitled to a prejudgment interest of $373,671.88 from Kesha due to her breach of the KMI agreement by making late royalty payments. Kesha's affirmative defense is that subject defamatory statements are not pleaded with sufficient specificity. Gottwald is libel proof. Subject statements are opinions or hyperbole, and the defamation claims are time barred, are dismissed. So all of those affirmative defenses are gone. Kesha made a false statement to Lady Gaga about Gottwald that was defamatory per se, and Kesha's breach of contract affirmative defenses based on the statute of limitations and possibility, California 7-year rule, unconscionability, and fraudulent inducement are dismissed. Oh, wait. So this is a matter of law. Kesha made a false statement to Lady Gaga about Gottwald that was defamatory per se. So that is done. She'll have to, I guess now they're going to figure out damages from it. And her breach of contract affirmative defenses are dismissed. Plaintiff's motion is otherwise denied and is further ordered that the clerk is directed to separately enter judgment in favor of KMI and against Kesha in the amount of this much. And judgment on Kesha's counterclaim, plaintiff's remaining claims are hereby severed and shall continue. And it is further ordered that Kesha's motion for summary judgment is denied. Further ordered that upon denial of Kesha's motion for summary judgment related to whether plaintiffs must establish actual malice and gross irresponsibility pursuant to CPLR 3212B, court grants partial summary judgment to plaintiffs on this issue. Plaintiffs need not prove actual malice or gross irresponsibility at trial. And it is further ordered that because of the viability of Kesha's affirmative defenses based on the implied covenant of good faith and fair dealing were raised by the parties and addressed, pursuant to CPLR 3212B, summary judgment is granted to plaintiffs on those defenses, which are dismissed. So there we go. So as for the defamation claim, the defamation claim is, I mean, they won on the issue. They'll have to argue out on the damages. And that's because damages on this particular statement are going to be very, very difficult to prove. They're per se defamatory, but how much damage did Kesha do to Gottwald by telling Lady Gaga that he abused and raped her or whatever? I don't know. Did that break a contract or cause a contract to fail and materialize? They'll have to make these arguments in court to determine what happened or what the damage is. It could be nominal damages. It could be like $1,000 because now Lady Gaga thinks that Gottwald drugged and raped Kesha and nothing ever happened, but her opinion of him was lowered. And if she never told anybody, how much damage did it do? I don't know. You know, they'll have to make the arguments. It's very fact intensive, and they'll be bringing claims. They'll be asking for a lot of money for that. They could say Lady Gaga is very influential in the industry. messed up potential contracts and recording deals that could have happened. She may have spread that around. Other people could have gotten, who knows? They'll have to figure it out. What's up? What's going on, Robonex? What do you mean, what's up with the chat? I don't even know. So there we go, guys. That's the thing. This is a pretty interesting order that's come out. Handling some issues in ways that some people may not think. Apparently, saying someone drugged and raped someone else is defamatory per se. I mean, who knew? Who knew? Yeah, I'll change the vid title to Kesha. I was thinking it was the opposite way. Lots of trolls? Oh, well, I mean, welcome to it. Welcome to it. But that's how it goes. But there you go, guys. That's how it goes. So big decision, lots of there's lots of really potent legal questions in here. It's an interesting look at defamation and how it can happen when it's not destroyed by a TCPA. And actually, I'll say this. Defamation being resolved on summary judgment is really, really strange. Like, it's not common. Shouldn't say it's strange. It's just rare. It's hard to get a fact set for defamation where they agree on everything. And also that it's not, that truthfulness is no longer in dispute. What Kesha should have done is raise some issue about the truthfulness of Katy Perry's testimony, cast some doubt upon it, given them a reason not to believe her. She didn't do that. That's how you'd fight it. Maybe she couldn't. I'm not saying that she failed or did something wrong. She may not have had the evidence. And if that's the case and Katy Perry comes out and says, "Nah, I didn't. That didn't happen." What do you do? Anyways, that's the document there. So let's get that off the screen. I guess let's go Let's go ahead and read these chats, and then we'll wrap up the show, and I'll move over to Twitch. Hopefully the trolls follow over there. That'll be great. It's always fun to have the troll patrol. WTF is Kesha? I don't even know. So there you go. All right, we're gonna do that. If you guys peace out during the chats, I understand. I will see you later. There will not be a YouTube show tomorrow outside of some very, very strange circumstances. We'll resume shows on Monday for your regularly scheduled programming. And yeah, we'll see what's going on. Maybe I'll have read the Johnny Depp case by then. Maybe then I'll have read it. So, anyway, Bad Dragonite says, "Hey Nick, sending you a package to assist you with your problem. I'll tell you now, it has a motor, runs super quiet, is pink, and is at least 9 inches. That's right. It's a low noise desk fan for recording spaces. Hopefully it helps you out." Hey, I appreciate that. Thank you. We'll figure it out. I'll have it aimed directly up my shorts to air condition my balls. Fluffy Side Up says, "John Michael Kelly's mom should have swallowed him." Ooh, Vor? So that maybe his sister would have been safe from his supposedly pedophilic behavior. Wow. Very, very direct of you, Fluffy Side Up. I do not know anything about that, and I would prefer to not know anything about JMK ever again. Don't ever want to talk about him. Michael Rule says, "Greetings from the Netherlands. When are you able to add the deposition live streams to the podcast playlist?" I'm I'm thinking I might retool the entire podcast playlist because things got all messed up on it and it's so far behind. And I got to figure out a good system for it. But I want to redo it. I don't know how. We're going to figure it out though. Okay? So the answer is I don't know. Jason Stroud, we're going to finish Conversations. I didn't want to do it tonight because I couldn't tweet it out. I couldn't tweet out the show. It was short notice, and it's on a night that I didn't normally stream. So I was going to not... I'm going to have Conversations on when I know there will be the full normal audience. All right. Don't worry. Plenty of Conversations coming. No one important says, welcome Nux Taku and the Quartering to the club. Nux Taku for roasting Funimation, its hypocrisy, and the Quartering for fighting for Vic's spot in KitchenerCon. Hey, thanks, guys. I appreciate that. Biden the Cold One says, hey, Nick, sending shekels from the hospital. What are you doing in the hospital? Rogue says, there's no cure for the JMK virus. Stay hydrated. Mario Carter 13 says, ironically, Katy Perry's last album was Witness. Some nobody says, tell Twitter I said to die on a butt hook, MFers. Okay. Rick Nikita says, I expect to see you in LA on March 28th. I can't. I'm already going to be in Wisconsin on March 28th. So I've been booked for that for a long time. Which sucks. Because I would love to go to LA for Road Rage 2. Road Rage LA Part 2. I would love to, but I can't. Drago and T800, welcome to channel memberships. I appreciate it. Batgoat says, trade the NES for an N64. I can EM you the details if interested. No, I like my NES. I don't want an N64. Thank you. Finnegan Chief says, sipping a gin and tonic and celebrating passing my AWS Cloud Practitioner exam this morning. Cheers. Hey. Cheers back to you. Liak's a very smoky whiskey. It's really good. But you can't drink it quickly. Okay. Tinfoil Oracle, welcome to the stream. Or welcome to channel membership. Thank you. Skeet Meat says, Nick, are you going to the Dick Masterson Road Rage event? I'm autistic and I need emotional support from my favorite Chaos Marine. God, I would love to go. Oh, I'm so mad. You have no idea how much I want to go to LA, visit Dick and Larry and Keen Mangoes and everything. I just can't. Just can't. RM was here. JMK is a Spurg in his own echo chamber. That ratio. Almond John 1 says, pancakes or waffles? Waffles. John Haynes says, yeah, when I was using my job as a security guard at a total confinement facility for civilly committed sex offenders, I was in a bad place. Yeah, when I was using my job as a security guard at a total confinement facility. In reference for shelter from your family. Oh man, that's not the kind of shelter I would want at all. F says 100K in the context of the world population is like, that's not even a tenth of the population of Austin. That should be fair to say about Vic. Some nobody says this looks like Twitter targeting conservatives. It's just Twitter favoring an idiot. Zarin 2006 says, thanks for fighting for innocent men. I was nearly kicked out of college for a false claim and it nearly broke me. Seeing you stand for Vic gives me hope. Oh, I will take my share of the GoFundMe now. Check's in the mail, buddy. Almond John 1 says, if you don't eat the soup, we'll make you. So eat the soup, bigot. Kizzy says, I've never been much of a mobile gamer, but forget everything you think you know about mobile games because Raid Shadow Legends is one of the most... Chengiz Khan says, will Ty use Conversations as evidence? I don't know. Maybe. Some nobody says, had Kobe steak, $220 for my birthday. It was all right. Oh, that's sad. Mario Carter 13 says, Dr. Luke once called Kesha a fat effing refrigerator. Oh, God, that's funny. Okay, thank you. Some nobody says it's day 16,198 and Monica is still a horse person. Changiz Khan says, Nick, get effed. Enter child rackets, lol. Well, it's the baby, though. She will probably say it tomorrow. Matt Field says, you scared Nick's kids, JMC. Go away, creeper. Who's JMC? Ty Bruner says, that rant was more salty than some of your rants, Nick. Woof. That's Spectre's rant. Spectre's words are his own, by the way, not mine. Fires Deep, welcome to the channel. Thank you. Anime Girl 2.0 says, where can I see these videos? Which videos? Oh, Spectre's videos? I don't know. I assume on his channel. I don't know what it is. I think his old channel got yeeted and he's got a new one, but I don't know what it is. So you'll have to maybe ask him on Twitter. Samurai Zenji says, what a beta. He sends 2 super chats to get noticed. Hope that $40 is worth it. Lol. And what did he get? Gugots. That's what he got. Okay. Some nobody says Shane Michael Vincent equals Jahan Mikkel Kelly. Okay. I ate the juice. Says, yesterday I was ramming my boyfriend from behind. Then out of nowhere, he reaches back and tickles my balls. I'm like, dude, WTF, you gay or something? Woo. Some nobody. Oh, wait. I missed this one. Kayama Kumori. Says, I'm kind of all right that Funimation is no longer dubbing Interspecies Reviewer. If Wikipedia is right, the Monica Rial was going to voice a 500-year-old elf prostitute. Yep. Some nobody says Jan Michael Vincent is greater than that other douchebag. Timothy Reaper says, what was that possible JMK website again? Are you talking about the one that Doom Guy sent? Oh my gosh. Sorry, Doom Guy sent a website called johnmichaelkellyisapetto.com. Is that what you're talking about? Because it might be johnmichaelkellyisapetto.com. If that's the website you're talking about, then it's johnmichaelkellyisapetto.com, and you'll have to check it out. I don't even know if it's real or just a joke. Rural says, love the show. Hey, thanks. Nick Naylor says, I went to johnmichaelkellyisapetto.com. Worth it. Oh, no. DCV Titan says, johnmichaelkellyisapetto.com is a legit URL. So there you go. Again, I don't know anything about it. Nobody says, humans do the sex sometimes. Shocking. That is true. They do sometimes do that. Mario Carter 13 says, saw a $69 hentai grab bag at AnimeCon once. Yeah. Lots of anime conventions have hentai. Some have strip shows. Some have all sorts of stuff. After dark panels can be all sorts of degeneracy. Some nobody says, she comes back. You got a Hurricane Rana her rules. Is that Hurricane Rana? Is that was that Neil deGrasse? No, that's not Neil deGrasse Tyson's wrestling move or whatever. Asia Frazier says, shut people down if spam. What you got against Hormel? Everything. They stink up my whole town. Davey Jojo says, anime community, is it a club? Where can I apply for a card? At Anime Club HQ, screeching zealots were never fans. They claim to be so they can spit their venom while claiming authority on the subject. Oh, yeah. I mean, we know this. We know this. DCV Titan says, is there a something sexual mug? I don't think so. I don't think so. Creastor says, Nick, see you at February 29th, February 29 a.m. Catch my email coming to Kitchener. I'll be asleep when you read this. I got your email. I've seen it and read it. And yeah, I will respond. But yes, I'm looking forward to it. John Haynes says, pretty cool. Glad I figured out Super Chat. Hey, me too. Me too. Rancine Hernandez says, sup, Nick? Been a while. 2 questions. 1, are you planning to go watch the Sonic movie? No. 2, have you watched Interspecies Reviewers yet? No, I haven't. I hear I should, but I think it might be sinful. Enter the QB says, what's your win-lose record in your lawyer career? I don't know. Most lawyers don't have a record, so to speak. And most of my cases settled out. So of cases that have not settled out, I've won all of them. But that's not very many. Trying to think. Yeah. I mean, so motion practice in criminal cases, oftentimes you move to dismiss criminal cases and that doesn't work. But so there are individual losses on motions and stuff like that. But generally speaking, any cases that have gone to a final resolution in court, I have won them. I'm not giving myself any particular props for that. My cases were good. My clients were good. That's just how it goes, right? Cases that I didn't know if we could win or whatever, we settled. So, yeah. Next is Bad Dragonite says, I've never been much of a mobile gamer, but forget what you know about mobile gaming. Raid Shadow. Oh, wait, I read that one. So there you go. Thanks. So. So there's that. But yeah, the cases that I've actually had to resolve at any sort of trial are family law cases. So their rules are a little bit fuzzy. I hate doing family law cases. I hate them. So I try not to. Never had to take a criminal case to trial. We either got them dismissed or they got settled out. So there you go. But like I said, I'm not professing, like I'm not bragging about that. I don't brag about that. I don't bring it up very often. If people ask me about it, I try to be honest. But you know, it's not me. I'm not flaunting my skills or anything like that. I've had good cases and been able to mostly work with decent prosecutors to get things settled out when they don't need to go to a full trial. And my goal in settlement is always keep my clients out of jail, keep their fines minimal, and we have a very good track record of that. So there you go. Yeah, let's change that video title right now. Kesha. That was the old bait and switch. I roped you in with promises of Katy Perry and I delivered Kesha. Rip. All right, guys. There you go. That's all I've got for you tonight. I mean, except for Twitch, which I'll do in just a few minutes. I gotta go grab a couple things. I got some cured meats. Finally. I did all the Justice Chat, Siren. Oh, wait. I missed that one. I missed yours specifically. Dang it. Siren Jag says, on another note, if you need your passport quickly, I am now the unofficial passport whisperer for KitchenerCon. I'll be your Jennifer Love Hewitt, minus the tatas, and point you to the light to help you cross over. Send me a DM on Twitter or Discord. I think my passport is up to date. So, but I'll double check. All right, guys. There we go. Let's play this outro. Thanks for joining me on a Saturday. It's a little random, but I always appreciate you guys being here. And if you want to come hang out on Twitch, come hang out on Twitch. So, there. It's not Dark Souls. I beat Dark Souls. It's beaten. So, yeah. All right, guys. There it is. Hope you all have a good night. We'll catch you Monday or right after the show on Twitch. By right after the show, I mean it's going to be about 15 minutes. We'll see y'all in a bit. Peace. Peace. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now.
Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more a love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who...
JXDBX says, thanks for the weekend stream. Funny thing happened to a TDS reviewer I liked. His video got punished for having that German symbol. He complained that YouTube should be going after dog whistles. Obviously alt-right. Obvious alt-right dog whistles. There you go.
Showcasing us his career. Get unemployed, so pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick.